Good evening, everyone. I'm Indrajit Kaur Bamra, moderator of this webinar. We are delighted to welcome you all in the webinar being organized by Committee on Commercial Laws, Economic Advisory and NPO Cooperative of ICAI. It is my pleasure to be a moderator in Know Your Law Series 41 webinar on how negotiable are the instruments under the Negotiable Instruments Act 1881, which is being organized by the Committee on Commercial Laws, Economic Advisory and NPO Cooperative of ICAI. In a short while, we will start this webinar. I would like to apprise you all about the committee. The committee is focused to encourage chartered accountants to shape strategy and policy that unlocks economic, financial, and social value while combining analytical foresight with commercial acumen. One of the core areas of this committee is to serve the multifunctional task of analysis, knowledge dissemination, inputs to regulators on policy formulation, to develop and publish technical guidance, background materials, etc., and to create awareness for professional opportunities for chartered accountants in commercial laws, economic advisory, and NPO cooperatives. Today, our eminent speaker will talk on how negotiable are the instruments under the Negotiable Instruments Act 1881 in this webinar, and we hope that the same shall be useful to the members. So, before handing over the session to our speaker, I would like to introduce Mr. Sanjay Butch, a senior advocate and solicitor who is also a member partner of Messrs. Crayford, Bailey and Company, practicing in Mumbai for past 3 decades and has been witness to the sweeping changes made in the regulatory and compliance environment. He is practicing and advising in the areas of business and corporate laws, restructurings, merger and acquisitions, corporate law, which include Indian company law, securities laws and regulations, including SEBI, takeover court, insider trading, corporate governance, capital markets, limited liability partnerships, foreign exchange management laws, competition law, property laws, arbitration, corporate litigation in business and commercial matters. And he is also serving as a legal advisor and an independent director on the boards of a few reputed companies. So I would like you all to welcome our speaker. So welcome, sir.
Very good evening to everyone, and I'm delighted to have all of you in this webinar, which is conducted by the Institute Committee. I am grateful for this invite. Do let me know when I can commence my presentation. I have a slideshow to make. Once the participants are there, do we have to wait, or we can straight away go on to business?
Sir, you please share your screen.
Okay.
Sir, we'll conduct the question and answer session in the later part of the webinar.
Sure. Okay, friends. So today we have assembled on this virtual mode webinar to sort of understand and decipher the most important law in the commerce and trade and custom. This is a very old law, and I think every one of us are broadly aware of what are the nuances of this law. But for the younger members and younger participants, this is kind of a sort of a classroom for them to revisit the provisions and understand the nuances of this very important law of 1881. So, friends, the topic today is how negotiable are the instruments under the Negotiable Instruments Act. So, this law, as I said, is 1881 and has been amended substantially, more so in last 8-9 years, right from 2015 and 2018, to make it more technology friendly, as also as everybody is aware that most check bouncing cases or dishonor of checks cases are pending all over India, and there is no disposal of those cases on a fast track basis. So, in order to expedite uh, the hearings and disposal of these commercial matters, government thought fit that they should amend the law in such a way that there is a faster resolution of these mercantile and commercial matters. So the object of this law, as has been historical and has been recognized by the industry time and again, is to facilitate trade payments and business payments and mercantile practice, which has been traditionally followed by uninstitutionalized, traders, buyers, sellers, and various other parties. The intent of the law is to ensure that there is a smooth transferability and smooth payment systems which can be ensured or enshrined in the provisions of the Act, and there has to be some element of negotiability. So we'll go each topic by topic. Moving on to next slide. So what is the term negotiable? So in common parlance, negotiable means transferable by delivery, and the word instrument means a written document by which a right is created in favor of some person. Basically, we are talking about, as I will move forward in the slides, of kinds of instruments which are piece of papers but can be simply transferred by delivery, and in some cases by endorsement and delivery. So it literally means a written document which creates a right to recover a sum of money. Right to recover a sum of money from a person who draws an instrument in his or her favor. A negotiable instrument is therefore a piece of paper which entitles a person or a recipient or a payee to a certain sum of money, and which is also transferable from a person to another person by delivery and endorsement of the instrument. So basically, this document, any kind of an instrument which is recognized under the negotiable instruments broadly, can be transferred n number of times so as to create a right or an obligation to pay the amount which is mentioned in the instrument concerned. Now, few characteristics of negotiable instrument. Basically, broadly, all three kinds of recognized negotiable instruments, which are promissory note, bill of exchange, and check, have almost common characteristics. But let us understand broadly how to ensure free transferability and easy negotiability of these instruments in the trade and the commerce. Negotiable instrument is freely transferable from one person to another without any formality. So you don't require any agreement or a long document to transfer this, transfer of shares or any other thing where you require agreements to enter into between the parties. It's just an instrument which is recognized by the Act and has a legal sanctity. Mere putting a name, date, and signature and endorsement, the instrument can be transferred. The property, that is right of ownership in these instruments, passes by either endorsement and delivery in case it is payable to order, or by delivery merely in case it is payable to a bearer of the instrument. No further evidence of transfer is needed. Therefore, I said there is no need for a detailed agreement which is required to transfer any property in this kind of instruments. Now, for a moment, pausing, let us understand the meaning of endorsement, which is very important for free transferability and uh, and negotiability. So, endorsement. What is an endorsement? Now, one has to bear in mind that the instrument should meet all the conditions prescribed under Negotiable Instruments Act 1881 for it to be honored by the stakeholders, by the parties, whether the maker, drawer, drawee, payee, bank, or anybody who's dealing in transfer of money or instruments. Unless those conditions, basic conditions, which are the requirement, the instrument will not be treated as a perfect instrument. And therefore, for free transferability and negotiability, the instrument has to be properly executed in favor of the drawee by the drawer or the maker. So, endorsement. Now, when you read, the property right of ownership in these instruments passes either by endorsement and delivery. So, what is the term endorsement? Now, endorsement means signing at the back of the instrument for the purpose of negotiation. The act of the signing a check for the purpose of transferring to someone else is called the endorsement of check. If no space is left on the instrument, then the endorsement may also be done by a separate slip which is attached to an instrument like a check or a promissory note or a bill of exchange. So when the maker of the instrument or the holder of that negotiable instrument signs the same, otherwise then as such maker, for the purpose of negotiation, on the back or on the face of the instrument or a slip of paper attached to it, or signs for the same purpose a stamp paper intended to be completed as negotiable instrument, he is said to have endorsed. He is said to have endorsed the same, and he is therefore called as endorser of the negotiable instrument, be it a promissory note, be it a bill of exchange or a check. Now, what kind of endorsements are prevalent in the industry as well as trade and commerce? Now, there can be an endorsement in blank or typically known as general endorsement. Now, what is a blank or a general endorsement? When the endorser puts his signature only on the instrument and does not write the name of anyone to whom or to whose order the payment is to be made, it is known as general endorsement. So again, to understand, a blank endorsement is such when the endorser puts his signature only on the instrument and does not write the name of anyone to whom or to whose order the payment is to be made. Second kind of endorsement is a special or a full endorsement. An endorsement is special or full if the endorser, in addition to his signature on the face of it or on the back of the instrument, also mentions the name of the person to whom or to whose order the payment is to be made. So, general endorsement would not have the name of the person in whose favor the endorsement is being made, and therefore it becomes a bearer instrument. A special or a full endorsement would bear the name of the person to whom or to whose order the payment is to be made. Generally, the parties to the endorsement are generally the partial endorsement which transfer the amount mentioned in the instrument and not fully is called a partial endorsement. However, under Section 56 of the Negotiable Instruments Act, a partial endorsement of the amount is not valid and not recognized. Third category is the conditional endorsement. An endorsement is conditional or qualified, which limits or negatives the liability of the endorser, which means an endorser may limit his liability for making payment in any of the two ways. One important way of limiting the liability of the person who endorses the negotiable instrument is without recourse or sans endorsement. The other one is by making his liability depending upon happening of a special event or a contingent event. Now, what is known as endorsement without recourse? Now, endorsement without recourse means without recourse or reference. As such, when the property in the negotiable instrument is transferred without recourse, the endorser negatives his liability and excludes himself from responsibility to all subsequent endorsees, which means he excludes his liability that anyone in whose favor the instrument, be it a promissory note or a bill of exchange, is endorsed, the endorsee cannot claim any endorsee cannot have any recourse against the endorser of that instrument. That is known as without recourse endorsement. This is the most commonest form of qualified endorsement and virtually prohibits negotiation, since the endorser says in effect that it is without recourse, which means this is one very important feature of the Negotiable Instrument Act, that if an endorser endorses an instrument without recourse or sans recourse, the further negotiation of that document stops, and the endorser excludes his liability from making any payment to the endorsee. Coming to the title of the holder of a check or a promissory note or a bill of exchange, a person who takes a negotiable instrument bona fide and for value, that is for value in terms of money, the instrument free from all defects in the title. The holder in due course is not affected by defective title of the transferor or the endorser of any other party. So basically, a person who takes a negotiable instrument, not under fraud or forgery, but bona fide and for value, he gets a full title free from all defects in his favor. And when he presents that negotiable instrument to the party, he is to be paid the amount mentioned in the Negotiable Instrument Act. So his title is free from all defects. Nobody can question that title. So there are some common characteristics of all three negotiable instruments. So one important thing is transferee can sue in his own name without giving notice to the debtor. Now, typically, the Negotiable Instruments Act provides that a bill of exchange or a promissory note or a check represents a debt due and payable as written on the instrument itself, and therefore it tantamounts to an actionable claim and implies that the right of the creditor against the debtor to recover money is intact, which means in case of a default or in case of dishonor or non-payment, the transferee or the holder of the instrument or the payee of that instrument can file a claim against the debtor to recover that amount. This is very important, right? And it keeps on transferring. That is a special feature of this instrument and under the Negotiable Instruments Act, is that this right keeps on transferring to those last of the subsequent transferees through endorsement and delivery. This feature can be explained by giving you a simple example, which I will in a simplified manner try to give you an illustration. Now, suppose there is a person known as Raju, the holder of a bill of exchange, who endorses that bill of exchange or a check to Shyam. Now, Shyam endorses to Babu, and Babu endorses to Anuradha, and endorses it again back to Raju. Raju, being a holder in due course of the bill by second endorsement by Anuradha, can recover the amount therefrom from Shyam, Babu, or Anuradha, and himself being a prior party is liable to all of them unless it is without recourse. Therefore, Raju, having been relegated by the second endorsement to his original position, cannot sue Shyam, Babu, or Anuradha. Where an endorser so excludes his liability, which is without recourse, which I explained, and afterwards becomes the holder of the instrument, all the intermediate endorsees are endorsers are liable to him. Again, by setting an example, Raju is the payee of the negotiable instrument. He endorses the instrument without recourse to Shyam. Shyam endorses to Babu, and Babu to Anuradha, and Anuradha again endorses it to Raju. In this case, Raju is not only reinstated in his former rights, but has the right of an endorsee against Shyam, Babu, and Anuradha. So this is what is the classic feature of the actionable claim and endorsement. The creditor can either recover this amount himself or can transfer his right to another person. In case he transfers his right to recover the money to the transferee, transfers his right to the transferee of negotiable instrument is entitled to sue, which means file an action on the instrument in his own name in case of dishonor, default, without giving notice to the original debtor of the fact that he has become now the holder and the original drawer is no longer a holder. So this is a distinction in the Transfer of Property Act and under the Negotiable Instruments Act. In case of transfer or assignment of an ordinary actionable claim, that is any book debt which is evidenced by entry in the books of accounts of the creditor, under Transfer of Property Act, that also qualifies as a receivable and also qualifies as an actionable claim. So under the Transfer of Property Act, it is mandated that for such kind of a transfer, and before filing a recovery action against the original holder or the drawer, notice to the debtor is necessary in order to make the transferee entitled to file a claim in his own name. So actionable claims are variety of actionable claims is insurance policy, shipping bill, or receivables, debt which is reflected in the books of account. All these are actionable claims recognized under the Transfer of Property Act. As against Transfer of Property Act, Negotiable Instruments Act gives a special feature or a special exemption of transferability, free transferability and negotiability, and provides that in such an event, n number of time person can transfer by endorsement and delivery the same instrument to variety and various people at the same time, or subsequent transfers can happen automatically without any notice being given to original debtor or the maker or the drawer of the instrument. And the debtor, original debtor or maker or drawer of the instrument cannot absolve himself of his liability unless it is sans recourse or without recourse endorsement, as I explained in the previous slide. Now, important thing about the Negotiable Instruments Act is that parties can freely trade, transact business by mere endorsement delivery of these instruments freely without any formality. And therefore, this act specially recognizes or presumes the validity of the instrument which is executed by the drawer maker of such instrument, be it a promissory note, be it a bill of exchange, or a check. So the law says that under section 118 and 19, following presumptions, that means that it is presumed, unless it is proved to contrary or rebutted by proof, that in respect of consideration, that every negotiable instrument was made, drawn, accepted, endorsed, or transferred for valid consideration in terms of money. As to the date mentioned on the instrument, that every negotiable instrument bearing a date was made or drawn on such date. So this is itself is a presumption. Nobody can deny this, that I had not executed this unless there are facts which can be proved that some forgery or interpolation of that instrument has occurred. As to the time of acceptance, that every bill of exchange, when accepted or was accepted within a reasonable time after its date and before its maturity. So that is a presumption for every bill of exchange. I'll come to the bill of exchange which is the only kind of instrument which requires acceptance of drawee or the payee. As to the transfer of the instrument, that every transfer of negotiable instrument was made before its maturity. Upon maturity, the instrument lapses and right to recover money also lapses. Every instrument needs to be presented before its due date or before its maturity. And therefore, presumption is that it is being presented before maturity and therefore it is valid. As to the time of endorsement, that the endorsement appearing upon a negotiable instruments were made in the order in which they appear thereon. As I explained to you, that one single instrument can be transferred multiple times or negotiated multiple times in the order of endorsement. Now, if the instrument itself does not have a place, one attaches a sheet of paper duly signed or a stamp paper to that instrument and gives the sequence of endorsement. It is simple, like in the olden days when the transfer of shares used to happen, physical transfer of shares. Today also in the societies where people are flat owners, if there are multiple transfers of the flat, the share certificate on the back of it, on the reverse of it, will bear various names of the transferees and the last of the transferee who's the current owner of the flat. Similarly, here also, endorsement appearing upon a negotiable instrument were made in the order meaning sequence order 1, 2, 3, 4, 5, 6, and so on and so forth, in which they appear thereon, as to who was the first endorser, who was the last endorsee. So that's the presumption. If it is properly mentioned on the instrument and duly signed on a stamp paper, attached sheet, if it is given, it is considered as valid instrument, freely negotiable and transferable. As to the stamp duty, that a lost promissory note, bill of exchange or check was duly stamped. Now, in certain cases, promissory note requires a revenue stamp, and bill of exchange also requires a revenue stamp. Now, check does not require any stamping, but it bears only the name of the person and the signature, and if it is a company, seal of a company for and on behalf of XYZ company. So that is a presumption that it was duly stamped unless proved contrary. As to the holder in due course, that every holder of a negotiable instrument is a holder in due course. This presumption would not arise where it is provided or where it is proved that the holder has obtained the instrument from its lawful owner or from any person in lawful custody thereof by means of fraud or cheating or unlawful consideration. In that case, the holder has to prove that he is indeed a valid holder in due course. So there is a limitation on this presumption. As to the dishonor of the instrument, that the instrument was dishonored in case a complaint upon dishonored instrument is filed with the court and the fact of protest is proved. So that is also a presumption that in case a complaint is filed for dishonored instrument, the fact of protest is proved is a argument which is to be disproved by the person alleging that it was not under protest or fact of protest is not proved. Now let's move quickly on the scheme of the Act. So this is divided into 16 chapters. Chapter 2 onwards, chapter 1 deals with definitions. Chapter 2 deals with notes, that is promissory notes, bills, bills of exchange, and checks. Chapter 3 deals with parties to the notes, bills, and checks. 4, negotiation. 5, presentment. 6, payment and interest. 7, discharge from liability on notes, bills, and checks. 8, notice of dishonor. 9, noting and protest. 10, reasonable time. 12, compensation. 13, special rules of evidence. 14, cross checks. 15, bills in sets. 16, international law, which is not relevant in the domestic trade, and 17, penalties. So this is the broad scheme of the Act. Now, moving to individual aspects of this, most important is the 3 kinds of Negotiable Instruments Act, negotiable instruments. Broadly, three instruments are recognized by this law. First one is a promissory note under section 4 and is defined to mean that it's an instrument in writing, not being a banknote or a currency note, containing an unconditional undertaking. Please understand these words: containing an unconditional undertaking signed by the maker to pay a certain sum of money only to or to the order of a certain person or to the bearer of that instrument. Okay, so now we will go for the characteristics of promissory note. What are the typical characteristics or the conditions for a valid promissory note? I'll move on. First, we'll touch one by one. First, we are dealing with promissory note. So I'll take you to the conditions which are required to be satisfied for a valid promissory note. So a promissory note must be in writing. It must contain a promise, an unconditional undertaking to pay. There are no conditions to be attached, or this cannot be dependent on a happening of an event or a contingency. It has to be a definitive, crystallized debt to be paid by the drawer of the instrument. The promise to pay must be unconditional. It must be signed by the maker. Maker must be a certain person or identity, or a company, or person's definition can include anything: HUF, LLP, individual, or anybody. The maker must be a certain person, so then his name should be under whose authority is he signing. Is he signing in this individual authority, or is he signing for on behalf of a entity, or otherwise? Payee's name also should be mentioned very clearly, and it has to be certain. The sum payable must be certain. The amount which is to be paid by the drawer maker to the payee should also be very certain. It can't be an ambiguous amount. The amount payable must be in a legal tender money of India, which is this, that the amount which is promised to be paid in the instrument should be in the Indian currency. So these essentials of a promissory note makes a instrument very valid, because unless these essentials are satisfied by the drawer or the maker of instrument, there are presumptions against him that the instrument may not hold a legal test or the validity of that instrument. Now, the maker of the promissory note is called the maker, and the payee to whom the amount or the money is to be paid is known as payee. Certain important points besides these essential conditions or characteristics of promissory note as prescribed under the Act. Stamping of promissory note is essential under the Indian Stamp Act. A promissory note drawn by a party has to have a 1 rupee revenue stamp or any other value prescribed under the Indian Stamp Act for it to be honored or for it to be valid in law. Countersigned by the maker of across the revenue stamp by the maker of the by the maker of the instrument to agree to pay or promise to pay in favor of the payee. The limitation period for promissory note to file a suit is 3 years under the Limitation Act from the date of signing or from the date of acknowledgement of that promissory note. Now, promissory note can be on demand, or it can not also. Normally, what happens in a promissory note is that if the date is not mentioned, if the certain date is not mentioned, it is deemed to be assumed that is an on-demand payment instrument, which means moment the maker of the instrument, or rather the payee of the instrument in whose favor the instrument is drawn by the maker, can immediately on by demanding the payment, can call upon the maker of the instrument to pay up. Next, we will deal with Bill of exchange. Section 5 deals with bill of exchange. Bill of exchange is an instrument in writing containing an unconditional order. Again, this is also unconditional. These are certain of the characteristics are very similar in each of these instruments. Containing an unconditional order signed by the maker, directing a certain person to pay a certain sum of money only to or to the order of a certain person or to the bearer of the instrument. Now, there is a difference between bill of exchange and promissory note, and I will take you to the essential characteristics of a bill of exchange. Now, what is the definition provided under Section 5? A bill of exchange is an instrument in writing containing an unconditional order signed by the maker directing a certain person to pay sum of money only to the person name or to the order of requested person's name, a certain person, or to the bearer of the instrument. So X purchases a goods from Y for rupees 1,000. Y buys goods from S for rupees 1,000. Then Y may order X to pay rupees 1,000. Mr. S, which will be nothing but a bill of exchange. So this is how the negotiability is ensured and transferability is ensured, and the payment and discharge is obtained through these instruments by way of a bill. So there's a variety of bill of exchange which are honored in the trade and the industry under these trading practices and customs, which I'm sure everybody is aware of. So this is a typical specimen of a bill of exchange. So it says on the left-hand side, rupees 10,000, place where it is being is to be honored, date, and the time when it is to be paid, to whom it is to be paid, and the amounts in words to Mr. accepted by and stamped and signed by the maker. So the typical characteristics is that a bill of exchange is necessarily to be accepted. There has to be an acceptance of bill of exchange for it to be negotiable further and honored as a valid instrument. Unlike promissory note or a check, which do not require acceptance, here the bill of exchange requires acceptance by the payee, in whose favor the bill has been drawn by the maker. Unless it is accepted, it can't be negotiated or honored. So these are the parties: drawer, drawee, the payee, which is visible on the screen. A bill where a time period is mentioned, just like the above specimen, is called time bill. But a bill may be made payable on demand also. This is called a demand bill. So if there is a time specific, it will be time bill, or otherwise it will be, if the time is not mentioned, it becomes an on-demand bill. Similar to promissory note, these conditions are necessarily to be satisfied by the drawer, maker, payee of the bill of exchange for it to be valid instrument honored under the Negotiable Instrument Act. It must be in writing. It must contain an order to pay. A mere request to pay on account will not amount to an order. Order to pay must be unconditional. It must be signed by the drawer. Drawer, drawee, and payee must be certain. A bill cannot be drawn on two or more drawees, but may be made payable in the alternative to one or two of more payers, which we saw in the earlier example. The sum payable must be certain. The bill must contain an order to pay money only. There cannot be any barter or there cannot be any mobile property which can be given under the bill of exchange. It must comply with the formalities as regards to the date, consideration, stamping, acceptance. This shows the typical difference between the two instruments. As to the number of parties, bill of exchange invariably has 3 parties like a guarantee. So there will be drawer, drawee, and payee. As against that, promissory note will only have 2 parties, that is maker and payee. Promise or order, bill of exchange should contain an unconditional order. Similarly, promissory note also contains an unconditional promise to pay given by debtor to the creditor. Nature of liability, the liability of drawer is secondary and conditional. in the case of bill of exchange. It is not a primary liability, it is a secondary liability and conditional liability. Whereas promissory note, the liability of the maker is primary liability and absolute, because a debtor-creditor relationship is established by issuance of a promissory note or a promise to pay. Acceptance. As I said earlier, bill of exchange requires acceptance to become a valuable instrument, whereas promissory note does not require acceptance, since it's a valuable instrument right from the beginning, establishing debtor-creditor relationship. Same identity of the payer and payee. The drawer and payee may be the same person in case of bill of exchange. In case of promissory note, the maker and payee cannot be the same person. It cannot be payable to bearer of the instrument. Whereas bill of exchange can be payable to bearer. It cannot be drawn as payable to the bearer on demand. This is the important difference between promissory note and bill of exchange. Protest for dishonor. It requires the protesting for dishonor. Promissory note does not require any protesting for dishonor. Now, pausing, what is a protest? I'll take you what is a protest, which is defined under the Negotiable Instruments Act. For us to understand when can a bill of exchange be protested, under what circumstances, and how it is valid. Section 100 of the Negotiable Instrument Act says that where a bill of exchange has been dishonored by non-acceptance or non-payment, the holder of that instrument within a reasonable time cause such dishonor to be noted and certified by a notary public. Such certificate noted by and notarized by a notary public then is called as a certificate of protest. It is basically protest for a better security. When the acceptance of a bill of exchange, when the acceptor of a bill of exchange, say for example, becomes insolvent, or his credit has been publicly impeached before the maturity of the bill, which means he is unable to pay his debts. The holder of the bill of exchange within a reasonable time will ask a notary public to demand better security of the acceptor of the bill. And on its being refused for honoring, he shall, within a reasonable period of time, cause such facts to be noted and certified by a notary public. So that certificate issued by notary public will be called as a protest for better security, because there is an acceptance mechanism. The protest of dishonor also requires to be notified by way of a certificate obtained from a notary public. So that is the importance of a protest under section 100 in respect of bills of exchange. Notice of dishonor must be given to all persons, including drawer, who is liable to pay. Whereas promissory note is usually on demand, that a separate notice for fulfilling the promise is not required to be given to the maker of the promissory note. Simply, if the payment can be demanded as listed out in the promissory note executed by the maker of that instrument, and failing which a civil proceedings for recovery of such amount can be initiated by the payee. Moving on to the third category of negotiable instrument. So we went through promissory note, we went through the bill of exchange and its characteristics and condition. Now comes a check. Check is defined under section 6, which is a bill of exchange drawn on a specified banker and not expressed to be payable otherwise than on demand, and it includes the electronic image of a truncated check and a check in the electronic form. So I will come to the modes of payment by bankers nowadays and the payment mechanisms, which are through electronic mechanism, use of technology and UPI payments little later. So let's first understand the essential characteristics of a check as distinguished from promissory note. And so the definition of check in the negotiable instrument has been amended via the 2015 amendment, as I said in the beginning of the talk, and includes now any kind of truncated check or a check in electronic form. And those expressions which are used are also defined and will have a same meaning as under the Information Technology Act. Expressions like asymmetric crypto system, computer resource, digital signature, electronic form, and electronic signature have the same meaning as they are in under the Information Technology Act. Now, a check is also a kind of a bill of exchange. It is distinguished from the bill of exchange, but it is certainly not a promissory note, but it's a bill of exchange, a kind of bill of exchange, but it has difference. Bill of exchange and a check has difference. Here, drawer is always a bank. Means the check is to be honored drawn on the bank, and the bank is the drawer. Whereas bill of exchange can be drawn upon an individual as well as a bank. Whether it is payable on demand, it is always payable to bearer on demand, whereas bill of exchange need not always be payable on demand. So that's a difference. Acceptance is not required in case of check, but acceptance of a bill of exchange is required by the drawee. Unless that acceptance is fulfilled, the bill of exchange is not honorable. Stamping, check does not require stamp duty or stamping. However, bill of exchange and promissory note requires to be affixed by adhesive stamps of required value under the Indian Stamp Act for it to be valid, enforceable document or instrument. Grace period or grace days, a check is not entitled to 3 days of grace, whereas a bill of exchange, unless payable on demand, is entitled to 3 days of grace. Pausing here for a moment, I will touch upon the instruments as are allowed to be having a grace period under the Negotiable Instruments Act. Just give me a minute. I'll just open the book and find out the section. So it is dealt with in sections 22, 23, and 24, which deals with maturity of an instrument or the grace period granted to instruments. It says that maturity of a promissory note or a bill of exchange is the date at which it falls due. Days of grace which is allowed. Every promissory note or a bill of exchange which is not expressed to be payable on demand but at sight or on presentment is at maturity on the third day after the day on which it is expressed to be payable. Basically, though the maturity is stated in the document, but a 3-day additional period or a grace period is granted on which it is expressed to be payable. All instruments except for the instrument payable on demand are entitled for 3 days grace period. However, no grace period is allowed in case of a check or a bill or a promissory note payable on site, at site, or on presentment or on demand in which no time is mentioned. So all demand instruments does not qualify for claiming a 3-day grace period as prescribed under these sections. Where the instrument is payable on installment, then each installment is entitled for a separate 3-day grace period unless the instrument is on demand. Now, how do you calculate this period of maturity? Where a negotiable instrument is payable on specified date, then it shall become payable on that specified date plus 3 days grace. So, taking an example, let's say, for example, a negotiable instrument dated 31st January 2020 is made payable at 1 month after date. The instrument is at maturity on the third day after the 20th February 2020, that is on the 3rd March 2020. If the last day of grace is a public holiday, then the instrument will be due on preceding business day. If the day of maturity is an emergency or unforeseen holiday, then the maturity day will be the following business day. All instruments are to be negotiated during the business hours and on the business days, or not on public holidays. Now, how these instruments are negotiated, I have explained to you earlier. But once again, in case of a promissory note or a bill of exchange or a check, it is payable to bearer, negotiated through transfer and delivery and endorsement. In case of promissory note, in case of promissory note and bill of exchange and check, it can be by way of delivery, or in case of promissory note, bill of exchange payable to order. If it is a bearer instrument, it will be by delivery. If payable to order, it will be endorsement and delivery both. Now, as we discussed, all three instruments have necessarily parties, which I will not touch upon once again. Next important topic is for the ease of negotiability or free transferability. The law provides, in terms of Section 8, what is known as holder of a promissory note, bill of exchange, or a check means any person entitled in his own name to the possession of the instrument and to receive or recover the amount stated in the instrument. Now, what is a holder and what is a holder in due course? The essential conditions. This is very important for a free transferability and negotiability of a valid instrument. Any person entitled in his own name to the possession thereof and to receive or recover the amount due therefrom from the parties thereto. So any person who holds or is in possession of a bill of exchange, promissory note, or a check is considered as holders, but the requirements are he must be entitled in his own name to the possession of the instrument. It can't be third party's name. It has to be in his own name so that he can validly, legally possess that instrument. He must be entitled to receive or recover the amount thereon from the parties thereto. So we saw that in case of promissory note, the maker of promissory note gives a promise, unconditional promise to the promisee or the payee to make payment on demand or on a specified date. Similarly, in bill of exchange, there is an unconditional undertaking or acknowledgement of debt to make the payment upon acceptance by the endorser. Second concept which they have dealt with is a question of holder in due course. Now, at times, a holder may be holder, but necessarily need not be a holder in due course. Because in case of a holder of an instrument, his rights, holder's rights are dependent on the transferor of that instrument, whosoever is making that instrument in favor of the transferee or the holder. The holder has a right to demand and receive the payment, but does not have a right to file a claim or an action against the maker of that instrument, just being a holder. Whereas in this case, also, it is not necessary that every person in possession of the instrument can be treated as a holder of that instrument. To be a valid holder, the person must be named in the instrument as the payee or the endorsee, or he must be the bearer thereof. So, unless these conditions are satisfied, which means his own name appears in the instrument as a payee or as an endorsee of the instrument, or he must be the bearer of that instrument in his own name, only then a holder will be considered as a valid holder. A person who obtains possession of an instrument by theft or by forging the endorsement is not a holder recognized under the Negotiable Instrument Act, and he cannot recover the amount as stated in the instrument under the Negotiable Instrument Act. An agent holding an instrument for his principal is not a holder, although he may receive its payment. Holder implies a de jure or holder in law holder, and not de facto, that is holder in fact holder, which means he has to be a legal holder satisfying all these conditions for him to recover the amount of money. Now, adjacent to this, a concept holder in due course is recognized under Section 9 of the Negotiable Instruments Act. Any person who, for consideration in monetary terms, becomes the possessor of the promissory note, bill of exchange, or check, if payable to the bearer or the payee or endorsee, if payable to order before the amount mentioned in it becomes payable, and without having sufficient cause to believe that any defect existed in the title of the person from whom he derived his title. Little complicated, but let's understand, break these conditions into parts. So one important condition is that it has to be holder in due course has to have possession of the instrument, that is either bill of exchange, promissory note, or a check for a monetary consideration or a value. He receives the instrument without the notice as to the defect in title of the transferor and in good faith. So therefore, he is not aware. He does not have a knowledge of a prior title defect who has transferred the instrument to him for further negotiation, but he accepts the instrument in good faith. The instrument is transferred to him, or he receives the instrument before the instrument is due for maturity. It can't be after the maturity or after the date. His rights, that is holder in due course, his right and title are independent of the transferor. If you notice, as against holder's right are dependent upon transferor's rights and title, whereas in holder in due course, his rights are without recourse to the transferor. He has not only the right to demand and receive the payment stated in the instrument, but also has a right to sue or file a claim in case the instrument is dishonored. Now, related term to this is also defined under Section 10, which is payment in due course. Payment in due course refers to a payment in keeping with the evident term or tenor of the instrument in good faith without negligence to any person in possession thereof. The payment will be regarded as payment in due course if a payment is done as per the term or the time mentioned in the instrument, it is made in good faith and without negligence, it is made to the person who possesses the instrument, who is entitled to as a holder to obtain payment, and payment is made in money and money only. Now, coming to the conditions, as we said, which I have already dealt with. Coming to important classification of various instruments which are prescribed under the Negotiable Instruments Act. Again, going back to the first few slides, which gives the scheme of the Act, and so we dealt with holder of an instrument, we dealt with holder in due course, and then inland instruments, and section 13 deals with negotiable instruments, kinds of negotiable instruments. But these kinds of negotiable instruments also have sub-classification. Now, what are those sub-classified instruments? So under Negotiable Instruments Act, you will find that there are bearer instruments. Two important conditions of negotiable instruments are to be satisfied to become a bearer instrument payable to only to the bearer of that instrument. These conditions prescribed under the Act are: parties to the transactions must express it to be payable, so payable to the bearer, or the only endorsement for it should be an endorsement in blank. When we discussed the kinds of endorsement, I explained to you about endorsement in blank and special endorsement, which are to be followed. So here, in the bearer instrument, it will be general endorsement or endorsement in blank without any direction or without any name being mentioned in the instrument. So that endorsement will be a general blank endorsement, not a special or a full endorsement. So typically, you would have seen that on the right side column of a check, there are two things in the which is written, which is typically like to the order or the bearer, and you have to strike off either to the order or the bearer, and then present it for honoring the check. Now, bearer instruments can be endorsed in blank, which means it can be transferred to anyone, which is a feature of free transferability and negotiability. A person who is holder of a bearer instrument can obtain payment of the instrument, as it is a blank endorsement. He can obtain payment without being an account pay check or a cross check or otherwise. Order instruments. Now, as against bearer instrument, order instruments are payable when the instrument expressly state them to be so. To whom or to whose order this instrument to whom is to be honored or paid by the payer or the obliger or the bank. They may be payable to order only to a specific person. There should not be any prohibition on their transferability. So these are the features of order instruments. Then there are inland instruments. As I said in the previous slide, so there are inland instruments under section 11, which are one which is either drawn and made payable in India or drawn in India upon some person resident in India, even though it is made payable in a foreign country. An inland instrument is drawn and made payable in India, or it can be drawn in India upon some person resident in India, even though it is made payable in a foreign country. Then there is a category of foreign instrument. Every instrument that is not inland automatically becomes a foreign instrument. These instruments are drawn in foreign country, but may be payable within or outside India. It must be drawn in India and made payable outside India and drawn on a person resident outside India. So that would be falling under the category of a foreign instrument. Then there is a category or sub-classification of demand instruments. Negotiable instruments in which no time is mentioned is called as a demand instrument. Then there is a subclassification of time instruments, where time instruments carry a fixed future date for payment is known as time instrument. Time instruments are payable at a fixed date in the future, as against the demand instruments. Then there is a classification, and it's very important for when anybody files a case for recovery or dishonoring of an instrument. One has to be cautious that these conditions which are prescribed under various sections in order to be a valid instrument, honorable and payable, it has to be a perfect instrument, and there are no conditions attached and there are no contingencies attached to such an instrument, be it a promissory note, bill of exchange, or a check. So any kind of an ambiguity or ambiguous instrument, which may be either bill of exchange or a promissory note for its holder, the holder of such instrument may treat them either as bills or exchanges or promissory note. Sometimes the drawee may be a fictitious person, or he may be incompetent to contract. Those ambiguous instrument are not to be honored and do not have kind of valid sanctity unless the definitive conditions which are prescribed, and we discussed about the parties, definitive amount, unconditional nature of the instrument, dates being mentioned, stamping of the instrument are met. Otherwise, they are treated as ambiguous instrument, not to be honored. So there has to be some degree of certainty in writing these instruments. Then comes inchoate or incomplete instruments. Now, incomplete instrument lacks certain essential requirements of a typical negotiable instrument, as we discussed the conditions and characteristics. In such cases, the holder of the instrument has the authority to complete it up to the amount mentioned therein. So sometimes you don't mention the date. The holder of the instrument before presentment can fill in the date. Sometimes the name of the party is not mentioned, and you enter the name of the party by yourself. However, the drawer has given you the blank authority to sign and present the check before on the stated date. Such documents are incomplete unless they are fully completed by the holder who's going to present that document or the instrument for honoring it, for making the payment. This in turn results in the creation of a legally binding negotiable instrument payable by law. Not only the first holder, but also any subsequent holder who procures such instruments can complete them to be meeting the requirements of the law and present them for honoring. Now, another important element is which I want to discuss and highlight is I will come to dishonor later on. First, I would like to touch upon, or rather, I think I will go sequentially in this case. Parties we have discussed, acceptance, endorsement, and all other aspects we have discussed. I wanted to touch upon the element of interest, payment and interest. Section 78 provides that payment of the amount due on a promissory note, bill of exchange, or a check must, in order to discharge the maker or acceptor, be made to the holder of the instrument. 79 deals with interest. If it is specified rate expressly made payable on a promissory note or a bill of exchange, interest shall be calculated at the rate specified therein. on the amount of the principal money due thereon from the date of instrument until tender or realization of such amount. Where interest rate is not specified on the instrument or the attachments, then the the interest on the amount due shall be calculated at the rate of 18% per annum from the date at which the same ought to have been paid by the party charge until tender or realization of the amount. So invariably, in case of dishonors or in case of delayed payments of instruments, interest is charged and interest is allowed to be paid under Section 79 and Section 80 of the Negotiable Instruments Act. Coming to when the liability stands discharged, Section 82 deals and provides that maker, acceptor, or endorser of a negotiable instrument is discharged by what? Discharge means legally discharged and free from liability to make good or make payment by simply cancellation and release and payment. So, promissory note once given check and bills of exchange has this category, peculiar feature wherein discharge can happen only if one satisfied with certain conditions, and those conditions are stated in section. I'll just open the book and try to explain how important that is for the discharge of the parties. Discharge from liability implies when the liability of the party ceases to exist. Modes of discharge as prescribed under these sections: one or more parties to a negotiable instrument may be discharged from liability in either of the following circumstances or ways: by cancellation, release, or payment as provided under 82. Cancellation of acceptor's name will discharge the instrument, and cancellation of any other party will discharge that party. By release, release of acceptor will discharge the instrument, and release of any other person will discharge the party. By payment, when the amount due on the instrument is paid by the party primarily liable on the instrument is considered as discharged and paid. Another way of discharge of liability is by allowing drawee more than 48 hours if the holder of bill of exchange, mind you, the word is bill of exchange, holder of bill of exchange, allows the drawee of that bill of exchange more than 48 hours, exclusive of public holidays, to consider whether he will accept the bill of exchange. All previous parties not consenting to such allowance of time stands discharged from the liability to such holder of bill of exchange. So there is a maximum time limit of 48 hours, which is provided by the drawee for acceptance of a bill of exchange. Third waiver which is granted, which is by delay in presenting checks. If a check is not presented within a reasonable time of its issue, and the bank fails and draws, and the drawer suffers actual damages through such delay, he is discharged from the liability to the holder to the extent of such damage. So check is required to be presented, as you all know, within the prescribed timeline prescribed by the RBI. Discharge can also happen by qualified acceptance. If the holder of bill of exchange agrees to accept qualified acceptance, all the previous parties whose consent is not obtained to such acceptance stands discharged from the liability to make good or make payment unless the holder gives notice thereof and the parties gives their consent to such qualified acceptance. Another way of seeking a discharge from liability to make good or make payment is by altering the instrument. Any material alteration of a negotiable instrument renders the same void as against anyone who is a party thereto at the time of making such alteration and does not consent thereto, unless it was made in order to carry out the common intention of the original parties. Because as I explained to you, there could be multiple parties, especially in bills of exchange, this is very common. Discharge of a bank. As per section 18(9), bank is discharged by payment in due course in case of alteration not apparent from the records. Now, coming to the topic, most important topic of dishonor and the notice of dishonor of the instrument. Mainly, this is in the practice and of business and trade. This is usually done in case of bouncing of checks and dishonor of checks on account of various reasons. So let's move on to what is a dishonor. These are essential conditions on which a check would be treated or rather uh, qualified to be dishonored by the banker. If the check is overwritten, it can be dishonored. If there are mismatched signatures, signature records not tally, the check will be dishonored. If it misses the essential condition of name of the payee, bearer, or to the order, it will be dishonored. If there is inconsistency in the amount in words and figures mentioned in the check, it will be dishonored. If it does not have, for some reason, nowadays the checkbook contains the printed accounts, but if it is the account of the payee is also not mentioned, then also it can be dishonored. If a stop payment order or notice is given by the drawer of the check to the bank for some reasons or the other, then the check will not be honored. If there is an order of a court for stopping the payment, the check will not be honored. If the account of the drawer is closed, the check will not be honored. Most importantly, if there are insufficient funds, and this is the major ground of litigation for all these years under Section 138 of the Negotiable Instrument Act, which is being fought by the commerce and trade time and again for long years, despite various efforts being made by the government to simplify the process. Still, there is a pendency of huge number of cases on this ground, that is insufficiency of funds. Of course, death, lunacy, and insolvency of the drawer will, if proved, will qualify for dishonor. Unverified alterations without drawer signature will also qualify for dishonor. Missing or incorrect date or date exceeding 3 months of the period will also qualify for dishonor of the check maturity. So it is very essential that the conditions which are prescribed under the Negotiable Instrument Act are met and satisfied to the fullest in order for the instrument to be honored for payment by the creditor, by the debtors, and by the banks and other institutions. Okay, coming to section 138 of which is the most debated section and litigated section in the entire Negotiable Instruments Act. Now, before a dishonor is now there can be dishonor of any of the instrument. So now under section 94, what is prescribed? Sorry, 93. When a promissory note, bill of exchange, or check is dishonored by non acceptance or non payment, the holder thereof must give notice that the instrument has been so dishonored to all the other parties whom the holder seeks to make severally liable. There can be multiple parties for endorsements, subsequent endorsement, and negotiable instrument. Therefore, he has to give notice to all the parties, not only the original or the first drawer of that instrument, but subsequent endorsees and subsequent parties through the negotiation chain, such that he can make all of them liable jointly and severally, independently also and jointly. 98 says no notice of dishonor is necessary when it is dispensed with by the party entitled thereto. So there is a provision that if you waive notice, then there is no specific notice of dishonor required. When a promissory note or a bill of exchange has been dishonored by non-acceptance or non-payment, the holder of that instrument may cause such dishonor to be noted by notary public, as I had explained, and that is known as a protest certified by a notary. Now, coming to section 138, which has a special provision made out, and the presumptions also made out in terms of section 138 to 142 of the Negotiable Instruments Act. So section 138 to 142 deals with dishonor of checks and provides for criminal penalties or action in the event of dishonor of checks for insufficiency of funds. The penalty which is prescribed under 138 is what? The drawer under section 138 may be punished with imprisonment up to 2 years, or with a fine up to twice the amount of the check, or with both. So it's a twofold penalty: imprisonment up to 2 years, or with a fine up to twice the amount mentioned in the check, or with both. However, for a perfect case of dishonor to be made out in the court, in the criminal justice system or the court, following essential conditions are required to be met. What are these conditions? The check should have been dishonored due to insufficiency of funds in the account maintained by the drawer with a banker for payment of any amount of money to another person from out of that account, that particular account. The payment for which the check was issued should have been in discharge of a legally enforceable debt or liability. There has to be a debtor-creditor relationship between the parties, and there has to be an element of recoverability of a debt, be it a book debt or be it mentioned through the negotiable instruments. There has to be an acknowledgement, admission, or enforceable debt or liability in whole or in part of it for it to qualify for a perfect dishonor. The check should have been presented within 3 months from the date on which it is drawn. So these are the three essential conditions before an action for dishonor can be started by the payee of the check or by the creditor who has to recover the amount from the drawer of that check. Under 139, there is a presumption. It shall be presumed that the holder of a check received the check for the discharge of any debt or other liability, unless it is rebutted or unless it is proved otherwise that the check was not received for discharge of any debt or legally enforceable liability. Typically, on this subject, whether it is an enforceable liability, legally enforceable debt or a liability, there is a host of litigation. And for a moment, we will pause here to, I will take you to some of the interesting judgments which have been passed in last few years on the issue of creation of security or deposit of post-dated checks and like, and what Supreme Court has said on these structured transactions, so to say. Pause for a moment. I'm stopping the share and moving on to some other slide. Wait for a moment. Okay. So, is the slide visible?
Yes, sir.
Yeah. So, coming to post-dated checks placed as security or otherwise, the courts time and again, this judgment of Indus Airways came in 2000 and Indus Airways came in 2014 by, and Supreme Court said before the two-judge bench that whether dishonor of post-dated checks which were issued by the purchasers towards advance payment would be covered by a Section 138 action if the purchase order was cancelled subsequently. It was held that Section 138 would only be applicable where there is a legally enforceable debt subsisting, that is, existing on the date when the check was drawn. If the debt was not subsisting or existing on the date when the check was drawn, then it will not be treated as legally enforceable debt. In Sample A judgment, Supreme Court again in the year 2017 held, and the facts were the respondent advanced a loan for setting up a power project and post-dated checks were given for security. The checks were dishonored and a complaint was instituted under Section 138. Distinguishing Indus Airways judgment, which we discussed earlier, it was held that the test for the application of Section 138 is whether there was a legally enforceable debt on the date mentioned in the check, on the date of drawing of that check. It was held that if the answer is in the affirmative, that the provisions of Section 138 would be attracted, otherwise not. Third case, Sunil Todi's case, a two-judge bench of Supreme Court in 2021 expounded the meaning of phrase debt or other liability. This debt or other liability or enforceability became the subject matter of interpretation. It was observed by the Supreme Court that the phrase takes within the meaning a sum of money promised to be paid on a future day by reason of a present obligation. The court observed that a post-dated check issued after the debt was incurred would be covered within the meaning of debt. The court further held that 138 would also include cases where the debt is incurred after the check is drawn, but before it is presented for encashment. In such an event, the debt or other liability test would be also satisfied if it includes a case where the debt is incurred after the check is drawn, but before it is presented during the maturity prescribed period for encashment. Another case which is very prevalent and common in the trade and industry is placing the checks as security. So there are a couple of judgments which one must note. A check is issued as security to provide the drawee of the check with the leverage of using the check in case of drawer fails to pay the debt in future. Therefore, checks are issued and received as security with the contemplation that a part or the full sum that is addressed in the check may be paid before the check is encashed. So in Sripati Singh's case, which was decided by again Supreme Court in 2021, it was held when a check is issued even though as a security, the consequence of flowing therefrom is also known to the drawer of the check, and in the circumstances stated above, if the check is presented and dishonored, the holder of the check drawee would have the option of instituting or initiating civil proceedings for recovery or the criminal proceedings for punishment in the given factual situation. But in any event, it is not for the drawer of the check to dictate terms with regard to the nature of litigation, which means a drawee of the check is entitled to recover the money out of the security placed, either instituting civil proceedings, that is by filing a civil suit for recovery or enforcement of security, or uh, or initiating appropriate criminal proceedings under IPC. It was held in another case by Supreme Court that for the commission of an offense under 138, the check that is dishonored must represent a legally enforceable debt, which we all discussed, on the date of maturity or presentation. If the drawer of the check pays a part or a whole of the sum between the period when the check is drawn and when it is encashed upon maturity, then the legally enforceable debt on the date of maturity would not be the sum represented on the check. So, what it says is that when the security is created, X amount was due, part payment was made, so the principal amount got reduced on a reducing balance basis, and the new amount came into being, the reduced amount. But that amount is not mentioned on the check. Therefore, it will not be the sum represented on the check. When a part or a whole of the sum represented on the check is paid by the drawer of the check, it must be endorsed on the check as prescribed under Section 56 of the Negotiable Instruments Act. The check endorsed with the payment made may be used to negotiate the balance, if any. If the check that is endorsed is dishonored when it is sought to be encashed upon maturity, then the offense under 138 will be attracted. And therefore, in the initial phase, I explained the importance of endorsement and negotiability and free transferability, and the conditions to be satisfied of an unconditional undertaking to pay. Amount has to be certain, date has to be certain, party has to be certain, and if there is an endorsement, proper endorsement, legally enforceable endorsement, as prescribed under the Act and as highlighted by Supreme Court in this judgment, the conditions of dishonor would get attracted under 138. Moving on to earlier slideshow.
Sorry, sir.
Yeah.
Okay.
Moving on to the original presentation. After discussing a couple of important judgments for the benefit of audience. Now, let us see what is the procedure for initiating proceedings under 138. Simple procedure is that a check is issued by the drawer. The payee holder presents the same for payment. The collecting bank informs the payee holder about insufficiency of the funds and issues a memo of dishonor. The payee or the holder in due course of the check should therefore give notice demanding payment within 30 days from the drawer. In receipt of that information of dishonor from the bank, that is the memo of dishonor received from the bank, he should give a 30 days period or the notice to the drawer, giving them an opportunity to rectify the situation by topping up the amount and allowing the drawee to represent the check for it being to be honored by the bank. Notice to the drawer can be served by ordinary post or even by nowadays emails and electronic systems. Drawer is liable only if he fails to make payment in the next 15 days of receiving such notice. So in all, 30 plus 15, 45 days time, maximum time is granted to the drawer either to sufficiently top up the funds in the account and rectify the situation such that it can be honored, or pay up the amount through other means so that the debt is satisfied within a total period of 45 days, 30 days notice plus additional 15 days notice. Upon expiry of 45 days, the payee or holder in due course of the check dishonored should have made a complaint within further period of 30 days or 1 month for it to be a valid complaint under 138, which means 45 plus 30 days, that amounts to 75 days time within which the essential conditions needs to be satisfied for it to be a valid complaint filed under 138. Under 142, cognizance of offense will be taken up by magistrate court of any offense that is punishable under 138 if time limit for filing the complaint is done and it is well within the time limit. No inferior court other than metropolitan magistrate or judicial magistrate of first class shall try any offense under 138. Most importantly, through the amendments made in 2015, jurisdiction of the court has been sort of changed in order to facilitate the payee for instituting such complaints. So a new section has been inserted, and that section is section 143A. It says, so not 143A, but under 138 itself, that the payee, instead of the maker or the drawer, shall have a jurisdiction where a complaint can be instituted. So in 2015, the government thought that there is pendency of a lot of cases all over India, and that the payee or the creditors are being harassed by the drawer of the instruments to drag them to the court, which is housed in their territory or in their jurisdiction or their offices or where the check is drawn. However, from 2015, the law has been changed. It says the offense under 138, which deals with the dishonor of check, shall be inquired into and tried only by the court within whose jurisdiction, if the check is delivered for collection through an account, the branch of the bank where the payee or the holder in due course, as the case may be, maintains the account or is situated. Earlier, what used to happen is that it was necessary to file a complaint in the area or in the territory or a jurisdiction where the bank was located who has dishonored the check, or where the drawer was located or situated. But now the facility has been given to the creditor or the payee, and it has been directed by the law that the court which shall have the jurisdiction will be the court in which in the territory in which payee maintains his account. Or second category is, if the check is presented for payment by the payee or holder in due course, otherwise through an account, the branch of the drawee bank or the payee bank where the drawer maintains the account is situated. So this facility has been given to file or institute a complaint in the jurisdiction which is convenient to the creditor or the payee. Now, moving to certain other amendments which came into being in 2018. Now, in 2018, this act was again amended substantially to facilitate the creditor or the payee to recover compensation. So, what the 2018 amendment provides now is that the payee and it is it's a non-obstante clause which says notwithstanding anything contained in the code of criminal procedure, the court trying an offense under 138 may order the drawer of the check to pay interim compensation to the complainant or the person who files or aggrieved party who files a complaint under 138 in two scenarios. In a summary trial, which means without going through the long drawn battle of legal battle of trial, evidence, witnesses, etc., in a summary trial on the first instance, or even at a summons stage, when the summons are issued, calling the accused or the drawer to present himself in the court, at that stage itself, the court is satisfied, and where the accused or the drawer does not plead guilty, and he says that I want to fight the litigation, I am not guilty of any dishonor, then the court can, on prima facie basis, award an interim compensation to the payee or to the drawee of that check. The interim compensation, however, should not exceed 20% of the amount of the check. The interim compensation should not exceed 20% of the amount of the check. Now, as we saw, under 138, there is a criminal liability of punishment or also fine of twice the amount of the check that is mentioned, or both. Here, out of that twice the amount, 20% of interim compensation can be awarded by the court in its discretion at a summary trial level or a summons case if the accused or the drawer of the check does not plead guilty and he says that I'm not admitting my guilt, I am going to fight the litigation. In such a situation, the court may award an interim compensation to the extent of 20% of the amount of the check as a relief, as a temporary relief, pending the final hearing and disposal of the entire complaint, which takes years. The interim compensation shall be paid within 60 days from the date of the order, or within such period not exceeding 30 days, which is mean total period of 90 days credit period, as may be directed by the court, if a sufficient cause is shown by the drawer of that instrument. Finally, if the drawer of the check is acquitted undergoing the trial, the court shall direct the complainant to repay to the drawer the amount of interim compensation with interest at the bank rate as published by the RBI. Now, similar to that, corresponding amendment is also made in the appellate structure. Now, under section 148 through the 2018 amendment, it is now provided that in an appeal by the drawer against his conviction held by the lower court under 138, the appellate court may order the appellant, that is the accused drawer who has been convicted by the trial court, to deposit such sum which shall be minimum of 20% of the check amount of the fine or compensation awarded by the trial court, for him to be eligible to prefer an appeal or for him to contest the conviction. So unless the amount of deposit is made, which is 20% of the total fine or compensation awarded by trial court, he is not eligible to fight his appeal before a higher court. And that condition has been now prescribed to reduce the litigation, needless litigation, time-consuming litigation by way of 2018 2018 Amendment Act. It is also provided in this section that that the 20% deposit which is required to be made by the drawer who has been held guilty or convicted by the lower court, 20% of the award compensation shall be in addition to any interim compensation paid by the appellant under section 143 capital A, which has come into force from 2018, which means this is over and above of 20% of interim compensation if it was awarded by the trial court at the first instance on a prima facie basis, and final award of compensation awarded by trial court, which means it tops up by 20%, which means it dissuades the convicted fellow to further prefer an appeal unless he deposits these amounts, 20% of the award and 20% further of interim. So total 40% unless he deposits before a higher court, he is not eligible to of being heard in an appeal against the lower court's order. So these are very important amendments which have come up in 2018. Now, we will deal with an interesting topic. What is the relevance of these negotiable instruments in view of the modes of payment having been changed? Now, if you see what are the other modes of payment in India, and recently with the advancement of technology, what all has happened, which and going further will reduce the physical instruments, except maybe in the case of demand promissory notes and bills of exchange used by the small traders and business community. So what has happened is now that they have now prescribed a different mode of transfers. So now what is prevalent is NEFT, which is National Electronic Funds Transfer, electronic transfer, real-time gross settlements, immediate payment service, IMPS, which is the UPI and 24/7 phone banking. Then international transactions, they have now using technology allowed SWIFT codes for interbank financial international transaction through the mode of telecommunication, basically moving on from physical settlements to online settlements like demat accounts, automatic transfers, and share transfers through the demat repository or fungibility of instruments. So the modes of transfer using the technology will also change the shape of Negotiable Instruments Act. Maybe at some point in time, once everything is digitized, and which is not very easy, it will take its own sweet time, especially for medium-sized, small-sized businessmen and traders. It's very inconvenient, but it is a reality. In such an event, I think more and more physical instruments like promissory note and bills of exchange will get reduced, and people will move on to different electronic mode of transactions. And therefore what has happened, and I highlighted the definition of the check, which has now come under 2015 amendment. So it says a check is a check is in the electronic form means a check drawn in electronic form by using any computer resource and signed in a secure system with digital signature, with or without biometric signature, and asymmetric crypto system, or with electronic signature as the case may be. So understanding the need of the hour, the law has been amended. The definition of check has been amended to even include check in electronic form. and under the Information Technology Act, as I highlighted earlier. And any one of these modes of transfer are also given protection. These modes of transfers are given protection under the Negotiable Instruments Act through Section 25 of the 25 of the Payments and Settlements Act 2007. Now, what Section 25 provides, and I'll just move on to the, I'll stop share and move to other slide, which is important for you to understand the technological advancement and amendment in law with a ways to enforcement of provisions of Negotiable Instruments Act. So Section 25 of the Payment and Settlements Act 2007 provides that where an electronic funds transfer initiated by a person from an account maintained by him cannot be executed on the ground that the amount of money standing to the credit of that account is insufficient, to honor the transfer instructions, or that it exceeds the amount arranged to be paid from that account by an agreement made with the bank, such person shall be deemed to have committed an offense and shall, without prejudice to any other provisions of this act, be punished with imprisonment for a term which may be extended to 2 years, or with fine which may extend to twice the amount of electronic funds. So this is a similar section in Payments and Settlements Act, the Systems Act, similar to 138 has been inserted in this Payments and Settlement Systems Act. Unless it is proved to the contrary that the electronic fund transfer was initiated for payment of any amount of money to another person for the discharge, the electronic fund transfer was initiated in accordance with the relevant procedural guidelines, the beneficiary makes a demand for payment of the said amount of money by giving a notice in writing. So these are the conditions which are to be satisfied and proved for a person to qualify for a dishonor remedies available under 138 to be sort of claimed by him. So subsection 5 of Section 25 of Payments and Settlement Systems Act says, provisions of Chapter 17 of the Negotiable Instruments Act shall apply to the dishonor of electronic fund transfer to the extent the circumstances admit. Explanation. For the purpose of this section, debt or other liability is defined to mean legally enforceable debt or other liability as the case may be, as I highlighted in certain Supreme Court judgment earlier in my presentation. Coming back to the original presentation, so I explained to you how the electronic transfers and modes of transfers are also protected under the Negotiable Instruments Act by these amendments which are being carried out in 2015 and 2018. Now, if you see broadly, and everybody must be aware that NEFT RTGS limits how much amount can be transferred. Minimum amount in NEFT is ₹1, RTGS 2 lakh, and IMPS, immediate system, the phone system or UPI or BeamPay, GPay is ₹1. Maximum transfer value depends on the consumer segment. There is no upper limit in RTGS. There is 2 lakh limit in IMPS. Type of settlement, NEFT can be done in various batches. RTGS is one-time settlement. IMPS is one-to-one settlement, immediately instant transfer through phone banking or GPay or UPI transfers. So there's various categories, the qualities of each one of these modes of transfers has been provided, and each one of these transfers, except IMPS, which will not qualify for sort of a check unless a legally enforceable debt or liability is established. for a dishonor of check remedy under 138. So with that, I think it's time, and I think I have tried my level best to cover this vast subject in a very basic and very layman's understanding, just to refresh everyone. I'm sure all professionals are aware, and they know about what all is required. However, since now we are in a era where compliance is sort of given more value, the conditions for a valid negotiable instruments are required to be satisfied at every stage, so that the instrument which is issued by the drawer maker in favor of payee are unconditionally and expeditiously honored by the banks and by the drawer maker, as the case may be. With that, I think I have dealt with most of the issues, especially with reference to dishonor, in my presentation. Thank you. I rest my case here.
Thank you so much, sir, for the insightful contribution and justice to the topic. So we have some questions from our participants.
Sure.
So shall I read for you? Okay.
Yeah.
Okay. One question from A.V. Ranganatha. What is the hierarchy of litigation? The highest being Supreme Court.
Yeah. Hierarchy of litigation with respect to Negotiable Instruments Act, or generally he's asking?
He's just
so there are, as far as we are today on the topic of Negotiable Instruments Act, the law provides that metropolitan magistrate, or the magistrate, chief metropolitan magistrate, or magistrate of first class in a district exercising jurisdiction of a criminal court is the lowest court where a complaint under 138 can be initiated, or a dishonor complaint can be initiated. After that, the trial happens, and any appellate jurisdiction will then go to the higher court, such as your High Court or Supreme Court, as the case may be. So that is the hierarchy in with reference to Negotiable Instruments Act.
Another question from A.V. Ranganatha. Can the pay approach Supreme Court if he fails in High Court?
Of course, if the question of law is involved, you must be aware that Supreme Court only deals with question of law and not question of facts. So any important question of law is to be decided. For example, the judgment which I cited had an interpretational issue of what is the meaning of debt, enforceable debt, or a liability. That those words are appearing in the Negotiable Instruments Act, and therefore the matter traveled from the lower court to the High Court to the Supreme Court, for Supreme Court to lay down the law of interpretation as to what is considered as enforceable debt or a liability vis-a-vis the dishonor of check complaint. And therefore, only question of law, if the leave is granted by the High Court, the matter travels to the Supreme Court. In case leave is not granted by the High Court, special leave petition under Article 32 requires to be filed before Supreme Court.
Thank you so much, sir. So another question from Manjunatha. After issuing the check, the issuer gives stop payment instruction to bank, and check gets dishonored. What is the solution for this?
Yeah, so the timelines are given. I explained to you that the timelines are given for you to write once you receive the memo of dishonor from the bank, to shoot out a notice to the drawer of the check to pay within 30 days. If he does not pay within 30 days despite notice, further period of 15 days is granted to him. If he does not still pay within 15 days, then within next 30 days, you become eligible to file a complaint, criminal complaint against him under 138 before the magistrate court and seek your remedy. And with these amendments under 2018 Act, you can even seek interim compensation to the extent of 20% of the check amount at a very start or a beginning of the case without going into a long drawn trial. That is the facility which through these amendments have come in.
Okay, sir. Thank you so much. So, one another question from Ganesh. Maximum period is 45 days or 15 days for the drawer to make payment under dishonor.
So maximum period, so 30 days notice is required to be given. First, the 30 days notice is required to be given. And another top it up by a 15 days period given to him. So in all, it becomes first 45 days. And then added to that 30 days, another 30 days is given to payee to institute a complaint. So first, within 45 days, if the amount is not paid either through that account or otherwise parallelly through his different account in discharge of legally enforceable debt or liability, then for that period at the instance of the payee of 30 days, he can institute or file a complaint against the drawer in the magistrate court, claiming compensation as well as the check amount with interest.
Okay, sir. So, one other question from Vinod Kumar. Whether there is option currently for filing complaints online for hassle-free solution in most of the cases and avoid the filing of the cases?
Yeah, so the work is in progress. Chief Justice of India has constituted an e-committee for digitization of most of the courts in India. Now, as you are aware, at central level, Supreme Court is also functioning, and they are accepting, in certain cases, the digitized filing versions. NCLT for company law matter is also accepting digitized filing versions. High Court has recently started accepting digitized online filing versions. Of course, it is not. It is fully functional or it is fully efficient at this point in time. It will take its own time before the systems and processes are settled, technology glitches are handled, and state government provides enough of infrastructure revenue to the local courts to get equipped with the e-com equipments and the filing modules or softwares for enabling the litigants to file online petitions or online complaints. As of now, magistrate courts in a district or a trial court in districts are not equipped with the required infrastructure for online filing. But going forward in next, I think I would say next 3, 4, 5 years, the plan of Government of India as well as the Supreme Court of India is to make efficient systems for online filing for most courts.
So, thank you so much, sir, for answering all the questions. So, I would like to give my heartfelt thank you to the speaker for their insightful contributions, the board of committee for their diligent organization, and all the participants for their active engagement. Your collective efforts have enriched our session, fostering a collaborative and impactful experience. So, gratitude to each individual for making this webinar successful and meaningful. So, thank you, everyone, and good evening.
Good evening. Thank you very much for inviting me to address this gathering of professionals. It was my pleasure to address this gathering. With that, Merry Christmas, Happy New Year to all of you. Stay safe. Bye-bye.
Bye.